Stop Los Angeles ICE raids. A federal judge rules. Welcome to Law and Society. Please subscribe. Today I'm going to briefly give you an update about the Los Angeles ICE raids. 5 plaintiffs and 4 organizational plaintiffs had sued the federal government in the Central District of California, claiming that they are violating, that the ICE agents or Department of Homeland Security and the federal government were violating the 4th and 5th Amendment and other statutory laws when they went after people in the Central District of California without any reasonable suspicion or probable cause. So I read the complaint to you, the amended complaint to you, that asks for a class certification. In the final order and in the reading of the final order, the court does not address the issue of class certification. I think it's because the organizations were part of the lawsuit, and organizations can't be part of class action suits. It has to be persons only. And I think that's maybe why he didn't go over, or she, I don't know if the judge is a man or a woman. I think it's a she. Yep, sorry. So she didn't go over the class action certification, but what she did was she granted the temporary restraining order, and also provided with guidance of how the government needs to conduct itself in order to make the arrests and detentions be legal. So in the conclusion, the court says, Kristi Noem shall provide access to room B18. Remember, B18 is a temporary detention facility that's located in the Central District of California, and that is meant for temporary keeping of detainees, but the federal government has used it as sort of a concentration camp, for lack of a better term, to put detainees there and keep them there for more than 24 hours without food, without water, without privacy to consult with their attorneys or even access to their attorneys. In instances where they've wanted to get access to attorneys, they have been drowned out by the noise of car horns that the detention agents kept on blowing, and therefore access to plaintiffs were denied for their attorneys. So the court says, Kristi Noem shall provide B18 with legal visitation by current and prospective attorneys, and legal assistance shall be permitted 7 days a week for a minimum of 8 hours a day on business days and 4 hours per day for weekends and holidays. Should exigent circumstances require closure for the safety of human life or protection of property, defendant must notify the plaintiff's attorneys and plaintiffs as soon as practicable, and certainly within 4 hours, to make alternative arrangements for legal visitation and or notice to affected detainees, attorneys, legal representation, and legal assistance. No such closure shall take any longer than reasonably necessary for the safety of human life or protection of property. The defendants shall give access to confidential telephone calls to attorneys, legal representatives at no charge to the detainee, and calls shall not be screened, recorded, or otherwise monitored. Court, having found a strong likelihood of success on the merits that the balance of equities overwhelmingly favor the organizational plaintiffs, the order that no security shall be required, so you don't have to provide with any sort of bond, is pretty much what that says. Why they should not be enjoined for further violation of the Fifth Amendment So Kristi Noem has to show cause on the date set forth by the court, answering why they should not be enjoined for further violation of the Fifth Amendment and the United States Constitution. Defendants shall be enjoined from conducting detentive stops in this district unless the agent or officer has reasonable suspicion that the person to be stopped within the United States is in violation of U.S. immigration law. Defendants may not rely solely on factors such as apparent race, ethnicity, speaking English or speaking Spanish or speaking English with an accent, presence of a particular location like a bus stop or a car wash or a toy yard or day laborer sites or agricultural sites, and the type of work one does. You can't use those as sole indicators of your reasonable suspicion. There has to be more particularized facts and assessments done in order for you to rise to the level of reasonable suspicion. Just a reminder here that the U.S. Constitution provides that we shall not be subjected to illegal searches and seizure without probable cause. Reasonable suspicion is a lower standard than probable cause, and in instances of immigration and immigration detention, the level of reasonable suspicion rises, and that gives investigating the government officials more than just the appearance of a person or their language or their presence in a place or the type of work that they do. It has to be more than that. So defendants are hereby ordered to show cause why a preliminary injunction should not be issued. Defendants are enjoined from conducting detentive stops without reasonable suspicion. Defendants may not rely solely on the factors that I just said. Defendants will maintain and provide documentation for detentive stops, including factors supporting reasonable suspicion, to plaintiff's counsel on a regular schedule. Defendants will develop guidance concerning how agents and officers shall determine whether reasonable suspicion exists when conducting the detentive stops. Defendants will implement associated training for defendants' agents and others involved in immigration operations in this district. So the court grants a temporary restraining order for the Central District of California, and says that this sort of case can come up and we can have a district-wide injunction. This is not a nationwide injunction. This is a district-wide injunction. And the court has the power and the jurisdiction to be able to take hold of this case and rule on this matter. So with that said, I wanted to give you an update on what's happening with the LA raids and the constitutionality of it. The court has found, the district court, that there's a violation of Fourth and Fifth Amendments, and that the plaintiffs in this case are likely to succeed on the merits, and that they will incur irreparable harm if this issue is not taken up right now, and the equitable relief of injunction and a temporary restraining order is not put in place. So with that said, thank you for listening. I'll keep you updated as more news comes along. Please like, share, and subscribe, and I'll talk to you soon.